So I guess the other good news was the fact that the Supreme Court decided not to hear this second um, affirmative action case out of about this Virginia magnet school, or did they hear it? I'm sorry if I have this one mixed up.
No, you got it right. That's exactly it. The
Okay.
court refused to take up this case called Coalition for TJ. It's about a magnet school in Virginia called Thomas Jefferson, and it's a really competitive school. They have had a lot of trouble in the past drawing in underrepresented racial minorities, specifically Black and Hispanic students. And so what the admissions officers decided to do was, rather than enact a race conscious policy, they enacted a completely race blind policy. So they didn't even know the applicant's race, but they adjusted their criteria to try to bring in more of these underrepresented students. So most notably, they allowed or held spots for students who came from middle schools that underperform, middle schools from often segregated neighborhoods, right? Middle schools with poor teachers. They said, we think that students who are able to excel at those schools should have a place at our school because they've proven against all odds, you know, that they can actually put in the work and that they're bright and deserve a spot here. And there was a big challenge brought by, I mean, really, it was white people, but they claimed to have been representing Asian Americans at the school. They claimed that the policy discriminated against Asian Americans. The appeals court rejected that and pointed out, this seems like very important, that the new admissions policy did not actually significantly reduce the number of Asian Americans at the school, did not mean that Asian Americans didn't still attend in large numbers. It just meant that there were also more Black students there. And the argument being pressed to the Supreme Court was basically, you know, it doesn't really matter if Asian American students are still competitive at this school. The fact that the admissions policies were changed to promote diversity is inherently unconstitutional.
And that is an interesting decision not to take that up, because the Supreme Court just dealt a significant blow to race-based affirmative action when it came to universities. Was the basis of this in any way touching upon the fact that this was a high school versus a college? What was the reasoning?
So look, we don't know exactly why the Supreme Court took up the case. I think that might have been one reason. The rules are different for high schools versus colleges. But I also think it would have been one hell of a bait and switch for the Supreme Court to take up this case and to strike down the new admissions policy, because in that affirmative action decision from last term, the majority specifically said we are not obliterating or prohibiting race-neutral criteria and admissions that are designed to bring in more diversity. And in fact, like, the people who invented this whole scheme were Republicans. George W. Bush created the top 10% plan in Texas as governor because he knew that it would bring in more Black and Hispanic students into the state's colleges. Like, this whole premise of using non-racial factors to bring in racial minorities, this was pioneered by Republicans as an alternative to affirmative action. The court has blessed it repeatedly. And yet the plaintiffs in this case tried to kill it before it even got a chance to take off, really. And so I think that partly maybe some of the justices, including John Roberts, who wrote that terrible affirmative action decision, recognized that, like, to strike down this policy would be to go back on everything the court has ever said about this exact approach to increasing diversity. Like, this is what the court had said it wanted. So how could it possibly come in now and say, actually, we changed our minds, it's unconstitutional?
Yeah, I mean, and that's also, it seems like it's also in keeping with what Roberts has been doing in terms of trying to maybe help the public relations as it relates to the Supreme Court at this point, and not be so activist on their own, on its face. But what was the bad news here, I saw you write about this, was Sam Alito seems to be very eager and signaling that he's quite eager to curtail anti-discrimination towards LGBTQ people in the country. He wrote this opinion in Missouri Department of Corrections versus Finney. What happened there earlier in the week, Mark?
Yeah, I mean, Samuel Alito was on a tear on Tuesday. He also dissented in this affirmative action case. He wrote this really quite personal screed attacking the Biden judge who wrote the lower court opinion. He said the judge's reasoning was a virus that would spread, and it was very strange. But he also wrote this opinion in the case you mentioned. This should not have been a Supreme Court case at all. What happened was there was a lesbian who worked for the Missouri state government. She faced discrimination. She filed a lawsuit. During voir dire, the attorney for this plaintiff, a lesbian, asked the jurors basically, how many of you were taught or believe that being gay is sinful? Some of them raised their hands. He said, okay, how many of you think that that belief could interfere with your ability to render a fair judgment? Some of them kept their hands up. He questioned 3 of them, and they effectively said homosexuality is a sin. It's sinful. It says there right in the Bible. Like, I believe that God decreed homosexuality is wrong. And then sort of said, but, in this case, I should be able to judge fairly. I just think that all gay people are sinful and essentially going to hell. The lawyers struck those jurors. The court affirmed that strike. The plaintiff actually won a pretty big payout in damages, which is great, relatively rare. The state appealed all the way to the U.S. Supreme Court, and the Supreme Court turned away the appeal, which is great. But Sam Alito wrote this separate opinion saying that, in effect, it violated the First Amendment rights of those anti-gay jurors to question and remove them from the jury for their belief that the plaintiff in the case is inherently sinful and engages in and lives a sinful lifestyle.
Okay, I've got to jump in for a sec. The prosecutors and defense attorneys can kick someone off a jury for anything, right? Like, I mean, a lot of the jury selection is strategy by the prosecutors or the defense attorneys too, where they vet people. I mean, say if you have too strong of an opinion on X, Y, and Z, or your politics may interfere with some particular case, they have wide discretion to kind of basically stack the jury in a way that they feel might be, beneficial to their case. So the fact that, as you say, this even reached the Supreme Court is clearly just a way to warm the bench to go after LGBTQ people again and tease up Alito to put this opinion out there.
Absolutely. And as a signal to, I think, other lower courts that are more extreme than Missouri's to try to press this issue. Of course, lawyers and trial court judges strike jurors for strongly held beliefs about all kinds of things every single day around the country. You believe strongly that the criminal justice system is racist. You believe strongly that tort reform is important to control medical costs. You believe strongly that, fill in the blank. You have a strong belief, you get struck. All the time it happens. What Alito is trying to do is establish a special privilege specifically for anti-gay bigots, where they are not allowed to be struck because their beliefs are cloaked in the garb of religious belief and religious faith and doctrine. And it would be another effort. I mean, he's been doing this for a while, right, not only to grant special privileges to anti-gay Christians, but also to really undermine the right to marriage equality itself. I mean, he begins this opinion not even by talking about the case at hand, but by complaining about marriage equality, complaining that the Supreme Court legalized marriage equality, complaining that it had led to all of these horrible consequences, treating anti-gay Christians as bigots. And I think that's, again, his sort of cri de coeur in multiple opinions over the years since the marriage equality decision in 2015, where he's saying we have to overturn marriage equality because it is abridging the First Amendment rights of homophobes.
Yes, and so I guess this is the preview for part of why this is bad and not ugly at this point is just because it just is an indicator of what's coming down the pike here. The ugly is this good neighbor EPA situation. It seems like the Supreme Court is poised to strike down this Clean Air Act provision based on what I'm reading, Mark, but I'm curious what your perspective is reporting on the Supreme Court. Can you explain what it is and what it looks like the judges might do here?
Yeah, I agree with the consensus that it's bad news for the EPA. So this is it's called the good neighbor rule. It's enshrined into federal law. The basic problem here is that there are a bunch of states that are upwind that have a lot of heavy industry that produce various emissions, including ozone emissions, which are quite bad for the environment, for human health, for pretty much everybody. And the downwind states, usually to the south or to the east, are the ones that suffer. It just so happens, in a kind of perverse twist of fate, that the upwind states tend to be red states and the downwind states tend to be blue states. So like all of the industry and pollution happens in red states and then the fallout happens in blue states. Right. So the Biden administration came in with this plan to try to limit ozone pollution in these upwind states. Again, basically red states. A bunch of the states filed suit. Federal courts blocked the plan in, I think, 11 of those states, but didn't block the plan in the remaining 12 states. So you have like half of a plan remaining. Those 12 states then went to the Supreme Court, joined by the polluters, saying, well, now you have to block the entire thing. And the Supreme Court is almost certainly going to do so. I mean, we could talk about this for hours. Like, the reading of federal law here that the states are putting forth is so absurd. The states are basically saying, we get to implement this law however we want. And if it doesn't actually reduce ozone and downwind pollution, it's not our fault or our problem. But I think the sort of perverse irony of the Supreme Court case is that the argument is, well, it's already been blocked in 11 states. So it might as well be blocked in the remaining 12 states, which means that the whole legal problem here was created by other federal courts blocking part of the plan. And now the Supreme Court is going to ride in on its horse at the last minute and block the plan in the other 12 states, meaning that there will be no plan at all and ozone will be largely unregulated. It's just another instance of the Roberts Court playing really fast and loose with environmental regulations and sort of manipulating the law and its own docket to do whatever it can to ensure that industry can pollute pretty much as much as it wants.
So if I'm understanding you correctly, they're using the fact that federal courts blocked some of this in other states as a way to say, well, we're basically being discriminated against, even though if those courts had not blocked it, the law would have applied equally to everybody.
That is exactly right.
Okay. That's insane.
And it's going to get 6 votes on the Supreme Court.
Because if they just said, no, this applies everywhere, the problem would be solved. The central basis of their claim of it being unfair would be completely eliminated, and then it could just be federal law.
Right. Their whole claim is, well, these other states don't have to do it, so we shouldn't have to do it now. And 6 justices are going to say, no, now the EPA has to go back to the drawing board. It has to redo all of the math. It has to open up comments for all the states, basically kicking the can another year or two down the road. It's just, I mean, it's almost sort of Trumpist in the effort to manipulate the courts to sort of run out the clock on a policy. That's what's going on here. There's very little true law involved.
Lastly on this, is this a preview of further attacks on the EPA in particular?
Absolutely. And I think what's especially troubling about this case is that it came to the court in a very weird posture. So the industry groups joined by these 12 other states, they filed an emergency application to the Supreme Court before their case had been fully litigated at the lower court, at the DC Court of Appeals. So the DC Court of Appeals has not actually rendered like a judgment in this case. But the states and the polluters ran up to SCOTUS and said, don't make us wait. Please don't make us wait. We want relief right now. And so SCOTUS jumped in before it even has a real record, before it even has a lower court decision, just to aid and abet the desires of these red states and industry groups. And that is just not how the appellate process works. Like, this is something that basically never happened before Brett Kavanaugh and Amy Coney Barrett joined the bench. It's another kind of shadow docket mischief thing where the court is using this supermajority to take up these cases prematurely, to do an end run around the actual appellate process and to help out the parties that they want to help out, polluters and Republicans here, before they have any right to even step foot at the Supreme Court.
Well, maybe we should have ended on the good news. I don't know, but we started in the way that we did. So, Mark, I really, really appreciate your time today. Thanks so much for coming on, and always good to see you.
Thanks so much for having me, Emma.
For sure.